Good afternoon, everybody. I'm joining you again today. My name is Chris Justice. I'm an associate with Samfiru Tumarkin, and I'm here today, as I always am, to hopefully answer as many questions as I possibly can in the time permitted. Anything to do with employment law, essentially. Just before I get into that, I just want to say I work out of the Toronto office at our firm, but we do have offices pretty much countrywide and growing at this point. So if you've got issues and you're not in Ontario, we still may, of course, be able to help out. But do send in any questions that any of you have, and again, I'll answer as many as I can. I wanted to start, though, just by sort of touching on a couple things I spoke about last time I was on, and that had to do with, of course, the pandemic, the ongoing pandemic. The first thing is, if you have been laid off and you're an employee who's especially been laid off for quite some time, dating back to March of 2020, you will need to take action very soon if you are considering going after the employer for some form of severance. There's a 2-year limitation period, which means you have 2 years from the day that you say you were terminated to effectively start a lawsuit. So just a reminder for anyone who's been on a layoff now for, well, almost 2 years, do get in touch with us, because if you're not going to get called back and you're looking for some severance, then you'll want to do that definitely sooner rather than later. The second thing I want to touch on, again, COVID related, has to do with, of course, the COVID vaccine policies that I'm sure all of you are aware of, whether you're working or not. These policies are becoming par for the course in terms of being a standard policy now, from what I understand, when it comes to both new hires and as well existing employees. And so if you're in particular an employee who is already working for a company and you're being presented with a COVID policy that requires you to be vaccinated, or perhaps as an alternative to submit to some rapid testing, and you do not wish to comply with that policy, and you're wondering what would happen if you don't comply, then definitely get in touch with us, because in all likelihood, most employers are not going to have the ability to terminate your employment or put you on some form of a suspension or leave of absence without actually providing you with severance. So again, if you're someone who is already on a suspension or a leave of absence, or who's about to be, or who perhaps lost their job due to non-compliance with their employer's COVID policy, definitely reach out to us and let us know, because again, there's a very good chance that you'll be entitled to severance and potentially other forms of compensation as well. So those were my two sort of more topical things that I wanted to point out to begin with. I did have some thoughts as well, more generally, in terms of what an employee should look out for when they're presented with a contract, and before signing that contract, what are some things that the employee should consider. I know that the last thing on anyone's mind going into an employment situation, for example, would be a termination. And yet the issue of whether or not there's a section in your contract dealing with a termination often comes up just on the back end of things after the job is no longer. So it's always good to be mindful of the termination provision or clause in the contract before you sign it. There's a good chance that what that clause is attempting to do is limit your entitlements in the event the company were to terminate your employment. And in many cases, this could mean the difference between you getting a few weeks versus you getting several months. So again, I appreciate it's not something on the minds of everyone going into a relationship, but if you're presented with a contract, and in particular, there's a termination provision in that contract, just be mindful about it. And if you have any questions about it, definitely talk to a lawyer before signing it, because you're going to want to be as informed as possible going in. Ignorance to the law will not necessarily be an excuse that you're going to be able to rely on later. So that's one thing, termination clauses. Another aspect has to do with compensation. So make sure that when you go into the employment relationship, and ideally it should be set out in the contract, make sure you understand how you're going to be compensated. And sometimes it's as easy as an hourly wage or a fixed base salary, but Other times it's not so clear. There might be bonus provisions or bonus plans involved. There might be commission structures. There might be certain targets that you have to meet in order to qualify. And a lot of times this isn't really detailed in the contract as much as it should be. And then there becomes an issue later on down the road when people are trying to argue that, they expect to get this amount of money or that amount of money, and yet nothing's in writing, and it can become a bit more troublesome to have to kind of navigate through all that. So again, it's always clear to be crystal clear when going into the relationship, and to have that set out in the contract. If there's references to other plans, bonus plans, anything like that, make sure, of course, you have copies of those before signing the full contract. So yeah, you just want to be clear on how you're getting paid, what you have to do to get that amount, whether it's realistic. Because sometimes numbers can seem great, but the chances of getting those numbers might be effectively nil. So these are things you want to clarify as well. Not to mention as well your job description itself. A lot of times employees come to me saying that their job has changed significantly than when they first started. And a lot of times that can amount to a clear constructive dismissal, and they could be entitled to severance. But other times there's a dispute as far as what that employee's responsibilities were, what that employee did, what that employee was expected to do. And if there's a very clearly defined job description or duties list, again, at the outset of the relationship before going in, that sort of gives a very clear picture of what it is you're responsible for, you're going to have a better idea of what you have to do, what's expected. And you're also going to be able to know better whether or not some of those duties or responsibilities are stripped away from you, perhaps unjustly. And then you can point back to that description and say, no, look, you've reduced my job by, boom, 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 X, Y, Z, all these different ways. So just another point in general about making sure you're crystal clear going into the relationship, knowing what's expected of you, how you're getting paid, what you're going to be doing, and also what happens on the way out. Are they going to be able to limit you as far as termination is concerned to your bare minimum entitlements, which again could just be a matter of weeks, or is there not going to be that in existence, or something else at play where you could possibly get as much as 2 years of severance or compensation? So it could definitely come into play, especially for longer term service employees. But having said all that, I'm just going to get into some of your questions. So thank you, first of all, as always, for those questions. Simona asks, or has a question saying New Brunswick. Simone, so I think what you were referring to earlier was whether our firm perhaps operates in that province. We do not. That is not a province yet that we're operating in. So I would suggest if you have legal questions, it would be most ideal if you could get those answers from counsel more local to your area. John Gibson from Facebook says, hi, I've heard people say that their employer is coercing people to take a vaccine. Is this true? How does the law look at that question? So, John, I guess it would depend in terms of what you mean by coercing. There are definitely many examples of companies who are, at least from my experience, who are insisting that their employees get vaccinated as per their policy. And they're perhaps in a way threatening, if you want to say that if they don't get vaccinated, they will be suspended or they will be terminated. And in a way that, of course, applies some degree of pressure on the employee. And I would imagine has led to employees or individuals who were initially opposed to getting vaccinated to get vaccinated. Now, I don't know if there's so much you can do after that point, but I guess the point I want to make is you shouldn't feel as though you only have one option, which is to get vaccinated or submit to testing. As I said before at the outset, if your employer is approaching you and demanding that you do this, you need to understand that you have options. It is voluntary at the end of the day. Now, does that mean there won't be consequences for that? No. But as far as what the law says, and the law is still sort of evolving on this issue, in my view and in the view of my colleagues, for the most part anyways, if you lose your job or you stop getting paid as a result of not complying with that COVID policy, you're going to be entitled to severance. So I don't think that the law would say that employer has cause to terminate your employment for failing to get vaccinated, particularly where there's no actual government mandate. And that's perhaps an important part to point out, which I spoke about last time I was on the show. And that just has to do with whether or not there's an actual government mandate that applies to your industry. Whether it's the airlines, for example, long-term care homes. Certain industries, there's certain mandates or laws in place. But it's really important to understand whether or not there is a mandate in place, because if it's just your company's internal policy and there's nothing from the government in that sense that demands or requires the employees to be vaccinated, then that employer is not going to be able to essentially get rid of you without paying you compensation. And that's a scenario that a lot of people are finding themselves in. And that's why I said earlier that it is highly likely that if you are in some way affected by non-compliance with a COVID policy, that you're going to be likely looking at some entitlements there, especially if you don't want to go back or you have no interest in sort of returning to that employer. So thank you, though, John, for your question. Crystal C on Facebook says that she was terminated from her job last month for not complying with the policy. Okay, just kind of what I was saying. That employer has now put all suspensions, terminations on hold until further notice. What, if anything, can I do to address this? How is that fair to those who were terminated already? Yeah, and I wouldn't say it is fair. And I would say that if you're in that group who was terminated already, like I mentioned before, you need to talk to a lawyer. You need to get some advice, because there's a very good chance that you're going to be entitled to severance. And if you're not going to comply with the policy, and the company is only going to have you work for them if you comply with the policy, then it only makes sense in most cases to go after what's rightfully yours as far as the severance is concerned, and again, maybe more. Crystal, in terms of your second point about the employer sort of seems like putting on hold suspensions, terminations. First of all, I don't know why they did that. Perhaps they got a lot of sort of blowback from other employees or lawyers on behalf of those employees, and they've had a change in tune. That's possible. But yeah, without further information, it's hard to know why they did that. All I will just say is that in your case, if you were already terminated, that you should get in touch with us, because I think we can be of some help. So thank you, though, for your question. Mark on YouTube asks, how does an unpaid leave factor into your severance? Are you still considered employed while on an unpaid leave, and is that calculated as part of your severance? So yes, if you are on a leave of absence, you are still, in most cases, considered employed. Now, I say in most cases, it depends how you view the case. So let me give you another example going back to COVID. If you are put on an unpaid leave of absence for failing to comply with the company's COVID policy, you are no longer being paid at that point. And you have a decision to make in terms of how you wish to treat that leave of absence. One person could look at an unpaid leave of absence and think, okay, this will buy me some more time. I'll get vaccinated, or I'll submit to testing, and I might not get paid for this period of time, but I'm going to return to work. And it may not necessarily mean that your employment is ended. But normally, when someone changes the terms of your employment without your consent to a significant degree, that is considered a constructive dismissal. And you can then have an opportunity as an employee to treat that as your effective termination date. So there's a couple ways that you could view an unpaid leave of absence. So I guess it just depends on the context and also what you're trying to achieve out of it at the end of the day. But again, back into the COVID-19 policy context, people who are suspended, without their consent and who won't stand for that and want recourse, have an opportunity to treat the first day of that unpaid leave as a constructive dismissal. The key thing is also consent. I mentioned this before. If you agree to the leave, then it may not be an issue, practically speaking. But if it's a situation where you don't agree and you object to being placed on that unpaid leave, then that's where you get into the circumstances where it could be a termination, and which could entitle you to some severance. And sorry, Mark, just one more thing on your question. You had asked, is that calculated as part of the severance? So again, depending on what you would select as your date of termination, you could include that time, or you may not. So if you consider the first day of your leave to be your termination date, then you're not going to likely be able to get credit for any time after that. If your termination date, for whatever reason, gets assessed at a later point in time, sometime in the middle of or at the end of the leave itself, then normally that time would be considered as far as for your tenure and as far as calculating your severance is concerned. So thank you, though, Mark, for your question. Just going through some of the questions. Thanks everyone again for sending them in. So Belinda on YouTube is asking, can a potential employer put health or medical status in your contract of employment, like the COVID vaccine? So I think what you're referring to is, can an employer essentially require you to get vaccinated as a condition of employment in order for you to start working for that company? And I think that that's a good question, because it's one thing to have a policy presented to you in the middle of your employment. It's another thing if you're applying for work and before you can become effectively an employee, you have to get vaccinated. At that point, for the most part, your employer is able to set the terms. It's more so just a problem when they change the terms in the middle of it, not so much, putting everything in writing beforehand, making sure you know what the requirements are so that you're clear as far as what you need to do to, potentially work for that company. They can generally make that a term. And I realize that is going to make a lot of people, it's going to take them a lot longer to find work. But it's nonetheless something that's generally permissible. So that's as much as I can say there. Sorry, just going through some more questions. So I know a lot of questions have come in about stuff that I've already talked about. I'm just trying to look for some others. Just bear with me. Tricky on YouTube asks, is there a time limit to apply for EI in BC after losing your job? Thanks. So Tricky, I'm not a BC lawyer technically. We do have offices in British Columbia. And in general, I would say for anyone who has issues and they're working or operating out of BC, give our BC offices a call, because they're obviously well-versed in all of these issues, whether it's EI, COVID, doesn't matter. So generally speaking, just know that we are in BC, and for those of you out there, give us a call if you have any questions. But as far as I understand, in terms of EI, Tricky, there is a general time limit to apply for EI. I would apply ASAP. There are some exceptions or some circumstances where people can get sort of an extension to the timeline. And then EI will kind of direct as far as, whether you're too late, if you can apply. So in your situation, I would generally apply ASAP, which is usually after you get your record of employment. And just on the issue of records of employment, your employer needs to generally provide you with your record of employment 5 days after there's been an interruption in your earnings, so about a week. And I know a lot of times I come across people who don't have access to their record of employment for months after they've been let go, after they've been suspended. Any time where your earnings stop, your employer is generally required to issue a record of employment. And that's going to be something that will assist you in terms of applying for and collecting EI. So if you have all that information, I would apply. Generally, I tell people to sort of apply within the month or two. But you should also know that EI can sometimes affect how much severance you can get from your employer as well, to the extent that there could be some overlap. But thank you for your question, Tricky. Sorry, going through some more questions. Nicole on YouTube is asking if the charter applies, the Charter of Human Rights and Freedoms, I take it, applies to the provincial mandate. It does not. That doesn't apply. The charter doesn't apply for private corporations sort of within the province. Pear on YouTube is asking if there's a difference between union and non-union, and there definitely is. We at this firm, we specialize in non-unionized matters. There may be a lot of similarities between the two, but one of the biggest differences has to do with the fact that for those of you who are in a union, you're going to be subject to a collective bargaining agreement. And that collective bargaining agreement is a lengthy document that's going to set out sort of what your options are, what remedies you have, what recourse you have, what processes you have to follow. And that's essentially what you have to follow in order to get any kind of legal recourse in a unionized context. You've got a union rep who represents the union, who normally it would be the go-to point in terms of asking questions, and it would be your union that advances a grievance on your behalf, and that would be all, again, set out normally in the collective bargaining agreement. So if you're looking at trying to get someone to help you out in a unionized context, in a case where your union may not be helping you, it's very difficult. It's very difficult, for example, for me as a lawyer to get involved in unionized matters. And so that's pretty much why we don't deal with that. But I would just say refer to your collective bargaining agreement. And if you have any questions, ask your local union rep. Otherwise, there are a lot of similarities in terms of, you can get severance if you're let go and that kind of thing. But it's just there's certain procedures that have to be followed that would prevent you from commencing a lawsuit, like would be the case if you were in a non-unionized sector. So hopefully that answers your question, Per. Thank you, though, for that. Got some more coming in. Thanks, everybody. So I've got a comment from Sarah on Facebook. Can federally regulated employers mandate the vaccine for a pregnant employee? No consideration. So, okay. So if there are definitely some sectors within the federally regulated environment that require vaccinations. The airlines would be one of them. They're not too many, to be fair, and there were some announcements of federally regulated sectors requiring vaccinations, and I'll just actually talk about that for a quick second because I think that's important. In October, I think it was, of last year, the federal government came out and said that it planned on requiring that all federally regulated employees get vaccinated as of early 2022. So, I mean, we're in that territory, or we're still, going into that territory, but early 2022. They announced this late last year. My understanding as of now is that they haven't actually officially put that into place. So, first of all, if you are a federally regulated employee right now, and you have either lost your job for not complying with a COVID policy, or you've been put on a suspension for not complying with a COVID policy, regardless of whether you're pregnant or not, there's a good chance that you're owed severance. There's a very good chance that you're owed severance, and you shouldn't stand for that if you don't want to. So again, if this has already happened to you, get in touch with us. Don't think that you're without options because there's a good chance there's some compensation coming your way. Now, Sarah, you mentioned, can a federally regulated employer mandate a vaccine for a pregnant employee? So I guess if somebody's pregnant, first of all, I assume that the individual who's pregnant still wishes to work. So they're not on, say, a mat leave. But so assuming they want to work, but they're just pregnant, and their employer is nonetheless insisting that they get vaccinated. I'm not a doctor, but I'm not aware of any specific side effects or anything that would occur with a pregnant woman taking the vaccine. I mean, obviously, I defer to the experts, the medical experts on that point. Normally, what I say to people is that if somebody is reluctant to get vaccinated, and it has to do with some health-related reason, it could be anything. It could be something related to pregnancy. It could be something related to a pre-existing condition that you have, an autoimmune deficiency, whatever the case is. If you're particularly afraid of or reluctant to get vaccinated for that reason or those reasons, I would say normally to consult with your doctor, get some form of a note or piece of paper that sort of explains why you shouldn't be vaccinated for XYZ reason, whatever it is in your particular circumstances. Provide that to your employer if you can. Now, your employer may still decide to suspend your employment or terminate you for not complying, and they may not buy the note or put much weight into the note from your doctor. And again, there's nothing you can there's nothing you can do to stop your employer from doing what it wants to do, but you can put yourself in a better light. You can, the optics of the situation can look better for you if, for example, you've tried to ask for accommodation from your employer and they just weren't having it. Or, for example, if you've submitted some religious exemption form or medical exemption form, it may not necessarily help out 100%, but it does still give off the impression that you're trying to do everything you can to keep your job, and it's they who are being more rigid and more resistant to accommodation. And then when you've got something like a medical note or something from a third party saying, I don't, recommend that they do that, then again, that just gives, I think, the employer something more to think about, and sort of adds an element of risk onto it. So whether you want to talk about human rights violations or just a failure to accommodate, given, like, say, for example, someone could work from home, so they may not even need to be around people. You as an employee want to sort of put forth those things. And then at that point, I mean, you've done everything you can do, but at least you've kind of built a little bit of a sort of a case, or you've sort of given yourself some ammunition, so to speak, if the company nonetheless decides to take rash action and let you go. And then maybe your case becomes, of course, more than just about severance. It can become about bad faith damages, human rights damages potentially. So I would say in general, if that's the situation you find yourself in, Sarah, I'd definitely say contact us, because I think we can be of help and do everything we can, obviously, to get you what you're deserving of, because it seems, like you're in a situation like a lot of us find ourselves in, but that pregnant sort of factor, I think, adds a little bit of a layer to it. But thanks for your question. Just going through some of your questions. Thanks again, everyone, for all the comments. It seems like, there's some comments in the chat about just sort of the scenario we find ourselves in today, in terms of conversations that employers and employees are having about, these medical injections. There's definitely no precedent to this kind of stuff. And obviously we haven't yet seen a case go to trial, as far as I'm aware of anyways, that, for example, involves somebody who didn't want to comply with a COVID policy, and whether or not the judge thought that severance or something more than severance was appropriate. I have no doubts that we will see these cases. It's just they take a little bit of time to get to the courts, but I myself and my colleagues are involved in many of them, so it's only a matter of time. But right now it is sort of a lacking precedent, and everyone is kind of up in the air as far as what's going to happen. But in general, we as the firm, we simply do not believe that your employer can do this, especially long-term service employees that put in that work, and get away with not giving you severance. So they may think they can do it, but again, if you find yourself in that situation, you give us a call, and because unfortunately you have to take that extra step. You have to kind of push that bit harder. I find anyways, in a lot of these cases, to have your voice heard. And so that's just the situation we find ourselves in. It's a necessary evil for a lot of these lawsuits to happen, just to get people the compensation they deserve. And again, if you find yourself in that situation, definitely give us a call. My time, however, is running out today, so I apologize to those of you who I didn't get back to. I appreciate all your questions as always. There will be more sessions of this going on all the time into the future. So if you do have any questions, definitely get in touch with us on some of our other sessions moving forward. Get in touch with our firm. Whether you're in Ontario, which we operate in BC, we operate in Alberta. We've got offices out in Ottawa as well. Contact our website, employmentlawyer.ca, as you see there down below at your screen. And again, thank you everyone for joining me today. It's always a pleasure, and I will definitely see you all very soon. Take care and happy New Year.